Alright, welcome back to another episode of Law Scholars. In this episode, we are continuing our discussion once again on criminal procedure and our discussion on reoccurring searches. In our last one, we talked about reoccurring searches of homes, which homes are afforded the greatest protections of the Fourth Amendment and that the Fourth Amendment can provide. In this episode, we are going to be talking about schools and prisons, and by nature of homes being the most protected, schools and prisons are less protected, obviously, than homes. So that is really how this is going to go about our organization. We'll talk about schools, and then we'll talk about prisons. Searches of schools and prisons are often considered administrative, and so, as I mentioned, they're afforded less protections. They generally do not require a warrant or probable cause to conduct a search. That is, the an administrative search requires only reasonable suspicion. So, let's talk about schools. State versus Jones. What is the court going to consider to see whether or not a search is reasonable? Well, the court is going to look at first whether or not the nature of the privacy interest of the subject is going to be infringed upon. Second, the character in the intrusion, and third, the relationship between the school concerns and then the nature of the search. So the relationship between 1 and 2. For a full search of personal property in a school setting, the standard is going to be reasonable suspicion as compared to probable cause and a warrant in a regular setting. We have a case that outlined that was just TLO. For a more invasive search of a student in a school setting, the standard is going to be reasonable suspicion for a regular search and reasonable suspicion of either 1, a dangerous situation, or 2, hiding the material within clothing. And a classic case of this, a very popular case of this, is going to be Safford School District Number 1 versus Reading. In this kind of situation, probable cause and warrant underneath the Schubert standard is still required in a regular setting. So, let me just restate those rules just quickly. Full search of personal property. Standard is going to be reasonable suspicion. In a regular setting, search of personal property is going to require probable cause and a warrant. That's not the case for school. It's just reasonable suspicion. If you're doing a more invasive search of a student in a school setting, such as a strip search, the standard is going to be reasonable suspicion for a regular search and reasonable suspicion of either a dangerous situation or hiding the material within clothing. In the real world, you need probable cause and a warrant to conduct a more invasive search. So, let's look at another case. We've got In Ray Gregory M. What happened here? Well, the student came to school, but he had lost his ID, and as part of the school policy, if you lose your ID, you need to leave your bag with the security officer while you are in the office obtaining a new ID. Well, the student left his bag. He was probably a little upset about leaving his bag. He threw it down or tossed it aside, whatever, or it doesn't really matter, but the security officer heard a metallic thud, which he thought was unusual coming from a backpack that was being tossed aside. Well, the officer felt the exterior of the bag, determined that it was a gun inside the bag, and then conducted a full search of the contents and did so within the dean's office, which ended up revealing the gun. So now this case is in delinquency court, and the student wants this evidence and of the gun to be suppressed. Is it likely to be suppressed? Well, what is going on in this case? This is an example of a frisk, and the standard in a school setting is if there is an evidence suggestion, which is basically no standard at all, there is an evidence suggestion that the weapon is concealed within the bag, you can conduct the search after you have done that frisk. If we were to contrast this with a search in a real setting, A real setting requires reasonable suspicion of a weapon in the first place to conduct a frisk. And here there was no evidence, reasonable suspicion of a weapon by nature of the sound. There was just an evident suggestion by nature of the thud that something was in the bag. And in a school setting, that was enough to get the frisk. So then we have Isaiah B. versus State. What happened here is that after gunshots were heard the night before, tensions were pretty high at the school. And because tensions were high, a search ended up happening amongst the students. The officer searched Isaiah B's locker, although he wasn't suspected of being a problem with the shooting that had happened the night before. And in his locker, he discovered a gun in that locker. The locker in this situation is owned by the school, not by the student, and so there is a limited expectation of privacy. And using the factors that we searched and that we discussed above, specifically the nature of the privacy, minimal because it's the school's locker, the character of the intrusion, minimal because you just opened it up to see if there's a gun in there, and then the relationship between the concern and the nature of the search. Again, reasonable because tensions were high from the school shooting. You wanted to solve the problem. Using those factors, this search was constitutional, and the evidence can be used against Isaiah B. Okay. We have Hagman versus Goshen County School District number 1. We want to compare this case with Ferguson versus City of Charleston. And in Ferguson, the program in Ferguson was disallowed because the purpose was to monitor criminal activity, and the punishment was pretty intense. What happened here is that there was a program of how searches were to be conducted, and those searches were pretty intense, and so it was disallowed constitutionally. Okay, let's transition now to prisons. We have one case to discuss, the privacy of individuals within prisons. This is McCoy versus State. And our rule says if a subject is convicted, there is no expectation of privacy, and the search can happen whenever, for whatever reason. If the subject has not been convicted, but is still on pre-trial, there is an expectation of privacy, which can be overcome with a security search. So if you're convicted, no reasonable expectation of privacy within the jailhouse. Not convicted, you have an expectation of privacy, but that can be overcome with a security search. Compare this with a Florence versus Board of Chosen Freeholders, where the officers can conduct a strip search no matter how minor the offense and the suspicion level involved when they were booking inmates. So again, booking, it's kind of a middle ground, but the court in that case determined that there was, no matter the offense and no matter the suspicion level, you can still conduct a strip search when booking inmates. Okay, so that's our discussion of schools and prisons. Pretty much they're administrative searches, and so they're afforded lesser protections, and this is because you have a lesser expectation of privacy within these settings. That's everything for this material. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, law scholars is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.